Hi there. I will be presenting on Epilepsy and Employment Law via the Americans with Disabilities Act. My name is Dustin Kidd. I am a professor of sociology at Temple University. I also hold a graduate certificate in disability studies from Temple University's School of Education. So I thought I'd start with a bit of a personal note about my journey with epilepsy. I do have epilepsy myself, which is what led me to this topic, in addition to my research related to disabilities more broadly. My diagnosis of epilepsy came in my early 40s. In around 2017, there was a moment when I was giving a lecture in a class on the sociology of popular culture to a class of about 100 students. And mid-lecture, I was mid-sentence, mid-thought even, and suddenly lost my train of thought, didn't know what I was saying, had to take a long pause, and couldn't get back to the moment before, couldn't get back to the moment where the previous sentence had ended. I had lost that thread altogether. Something that I think many people experience perhaps quite often, not related necessarily to a seizure whatsoever, but in my case it was a very new occurrence, something I'd never experienced before. I had to take some time in that moment to put myself back together again, try to find a new thread I could pick up on based on what was on the slide up on the screen at the moment, and just start talking all over again. As far as I could tell, my students never picked up on the fact that something was awry, but I knew that something had happened in that moment that I had never experienced before. I didn't have the language to describe it in that moment. I didn't know that it might be a seizure, which in fact it was. And in fact, it took a long time before I came to that understanding. And I only arrived at that understanding after a lot of additional symptoms over months that followed, after multiple visits to doctors, different types of doctors and so forth, and ultimately being directed towards a neurologist who was able to help me see that it was in fact epilepsy after going through a significant number of tests, exploring a number of other possible conditions as well, and then finally settling on epilepsy being perhaps the most likely, and then doing some overnight tests that showed that I was having numerous seizures in my sleep at that point, which indicated that I was likely having numerous seizures during the day as well. And consistent tests showing that I have a lot of unusual high levels of electrical activity in my brain that takes place, which can certainly impact cognition. So that's been my personal experience with epilepsy, but you're probably wondering why Lizzo is on the screen right now. Sorry, I should have mentioned that earlier. Lizzo is on the screen because that first seizure moment happened in 2017, and I didn't get the actual diagnosis of epilepsy until 2019. In March of 2020, as I'm still settling into that diagnosis and now trying to move from diagnosis to treatment, to finding the right medication that would treat and eventually stop the seizures, although it took a few more years before the seizures actually fully stopped. In March of 2020, I took a journey with some friends down to Puerto Vallarta, Mexico, with the plan of seeing Lizzo in concert on the beach in Puerto Vallarta, because a friend of mine works for a national chain of radio stations where they had been giving away tickets to see Lizzo performing on the beach, and they'd made arrangements for Lizzo to come down. We were all staying in the same hotel, although I didn't get to see her. The morning of the concert, because it was going to be a late morning show on the beach, the morning of the concert, I got up, I was having breakfast with my friends, and suddenly had my first and so far only grand mal seizure, where I fully collapsed over, violently shook for a while, and ultimately had to be taken to the hospital and stayed overnight in a hospital before being ushered to the airport by my best friend, who thought he just needed to get me out of the country back to the U.S. as quickly as possible. Put me on a plane alone to the U.S., get here, and promptly were put on lockdown. So I had to spend lockdown trying to figure out exactly how to get my seizures to stop, while also managing a department where I supervised 50 full-time employees, 20 part-time employees, trying to manage all of that at home alone, just me and my cat and my seizures. But I got through that, and I did find the right medications that treated my seizures. But that's led me on a long journey to try to better understand not just epilepsy, but also how epilepsy fits into this broader category of disability, and how disability helps to define our broader social world in a number of ways, particularly as it relates to questions around inequality and questions related to stories and storytelling and representation. So in this presentation today, I am going to discuss epilepsy in a bit more detail, both in terms of what it means for epilepsy to be a disability and in terms of the types of stigma related to epilepsy. I'm going to talk about the Americans with Disabilities Act in terms of its long history and the types of issues that are covered by the ADA. I'm going to review the definitions of disability as they are presented in the ADA. So not a more general sense of what is disability as defined by some other resource, but how does the ADA itself define disability, which gets at what is referred to as the social model of disability, and I'll contrast that with the medical model of disability, which is pretty frequently invoked as well. I'm going to discuss the concept of merit as it relates to legal cases, especially. We might think of it as legal or ethical merit, but in this case, because we're talking about a law, I'm going to focus specifically on legal merit, invoking phrases like a qualified individual and qualifying disability. I'm going to take a look at a specific example out of case law, and I call this Walmart versus Worker. And I say I call this because that is not the official name in the case law. It's a case that was ultimately settled, and so the name of the worker is not listed with the case at this point. If it was at some point, that's been lost to history. I'm not able to find that, but I can find examples or descriptions of this particular case in a number of places that has allowed me to do some research on this case. And I'm going to look at this from two perspectives, both Walmart's perspective and the worker's perspective. And then that's going to lead me to some conclusions that include both observations out of the case and some action items, some things we might do to imagine change as we move forward. So what does it mean to think of epilepsy as a disability? Frequently when I talk to people about having epilepsy and describe it as my disability, if I say that I am a person with disabilities and one of my disabilities is epilepsy, people will often say, well, that's not true. You're being dramatic. You don't have a disability. You have a condition. You have an illness. You take medication for it. It's treated. It's fine. To call it a disability is somehow going too far. It's invoking too much. They're not sure why I want to do that. And I think on some level they're trying to protect me from what I'll discuss on the next slide, which is stigma. They think that disabilities are stigmatized conditions, and there doesn't need to be anything particularly stigmatized about epilepsy. That has not been true for much of human history. Epilepsy was often seen as something quite abnormal, quite terrifying. It might be a reason why somebody would be abandoned by a community, put out in the woods, as it were. If a child was having seizures, that child might be abandoned. And until well into the 20th century, epilepsy was cause for annulment or justification for divorce, particularly if the epileptic condition was kept secret. Then it was considered a fraudulent marriage. And so the other party in the marriage was able to grieve that fraud and use it as justification for divorce. It was certainly justification for discriminatory practices in the workplace and so forth. Ultimately, the person with epilepsy was seen as somebody who could not be trusted to do their jobs, could not be trusted to perform their duties as a spouse or as a parent. And so it very much was seen as a disabling condition. moreover, epilepsy is a medical condition that is treated with medical interventions. And so to the extent that we see disability through a medical lens, it would certainly be justifiable to view epilepsy as a medical disability. I'm also going to talk today about a social model of disability, which looks more at how our physical conditions can interact with our social environment. For instance, our work environment, our community environment, our family environments, and so forth, to the extent that having a seizure or the threat of a seizure might make it difficult to perform my duties in a given day, particularly given the impact of a seizure on my cognition for a given period after a seizure, anywhere from 20 minutes to a couple of hours. Given that my job is very cognitively focused, it certainly impacts my job, or certainly can impact my job, and especially given how much I need access to my medication in order to get past those seizures, I absolutely do view it as a disability. And when people challenge that, I usually see that as an invitation to have a conversation about what exactly they think disability is and why they think they need to protect me from it by rescuing epilepsy out of that category of disability. Because I actually find really good company in being identified as a person with disabilities. I like being in that company, and I want to find that camaraderie with other people who have disabilities as well. So we're going to talk today a bit about what it means to be under that umbrella of disability. But with epilepsy in particular, there's also the issue of stigma. I was raised in a Christian home, and there are lots of different types of Christianity out there with different beliefs about different issues. In my particular Christian home, which was a Southern Baptist home, I was told to believe that epilepsy was associated with demonic possession, that if you read the Bible and you read stories about people who were possessed by demons, particularly in the New Testament when Jesus draws out some demons from a young boy, a frequent interpretation of that is that the boy had epilepsy, that the epilepsy was a marker of his demonic possession, and that those seizures, which were the expression of the demons, were ultimately stopped by Jesus' intervention. There are different ways that you could interpret that. One would simply be to say, well, there's demonic possession as one thing, there is epilepsy as another thing. They might be described similarly by writers, but they are two different things, so don't get them confused. Another approach is to say, well, epilepsy is a sign of demonic possession, and therefore if you see someone who has epilepsy or who is having seizures, you should be afraid because that means demons are nearby and present. And so that is terrifying and scary. A third interpretation, which I wish I'd seen more I wish I'd been given more access to, I wish I'd seen more representation of, is the idea that if it is a demonic possession, which I personally don't think it is, but if you were to see it that way, then you could say, well, what's wonderful about the Christian narrative is that rather than be afraid, that Jesus actually gets past that fear and steps in and shows caring and compassion for that young boy in a way that allows the seizures to stop. But that ultimately people with epilepsy, like any other people, they need caring and compassion rather than stigma and fear. But I have been plagued by that stigma ever since I was diagnosed with epilepsy in my 40s. I essentially had to come out as being epileptic to my mother and to my larger family after receiving that diagnosis. And that was a source of I would guess shame for my mother, although she never said that. But it's certainly not something that she likes to speak about. It's a source of tremendous discomfort for her. So if I can shift now to the Americans with Disabilities Act, I want to say a bit about the history of this act. The Americans with Disabilities Act was signed into law in June of 1990. The actual language of the act was finalized primarily in the fall of 1989 across the House and Senate, and it had been worked on for a number of years across the 1980s by a number of disability rights advocates, as well as by a number of policymakers. And it's a bipartisan act. There were people on both sides of the aisles who were working on this. It was particularly championed by Republicans after the attempted assassination of Ronald Reagan, which resulted in James Brady being hit by a bullet and being paralyzed for the rest of his life. He then became a tremendous advocate for people with disabilities. And so that moment was seen as really critical in the passage of the Americans with Disabilities Act. But so too were some really important political protests by people with disabilities across the 1980s, but those moments reached back into the 60s and 70s as well. A couple of those are represented in the photographs here. We had bus boycotts in San Francisco, Dallas, San Diego, Chicago, New York, and a number of other cities around the country, where people with disabilities would demonstrate in front of buses, place their wheelchairs in front of buses so the buses could not proceed, as a way to indicate that in some ways they are the folks who need access to the buses the most, and yet they had no access to the buses. The buses were not fitted for them. They were not designed for them to be able to board the bus and to use the bus. Now, if you've used a bus in Philadelphia or some other city in recent years, you know that most bus systems are now equipped to support people with disabilities, but that was not the case at this time, and so these bus boycotts were very important for drawing attention to that issue. And then on the left-hand side, you see this Capitol crawl, as it was known at the time, which is a moment when people with disabilities crawled up the stairs to get to the Capitol building in Washington, D.C. And this moment drew a lot of attention. Visually, it was incredibly symbolic to see people, most of whom were people with wheelchairs, who got out of their wheelchairs to crawl up these Capitol stairs. Actually, to go back to the bus moment just for a second, there was a hearing about bus policy in San Francisco when a number of people supporting the transportation industry who are fighting against legislation to redesign or retrofit buses were coming to testify to take a stance against policies to support people with disabilities and adapt an organization of a political organization that advocates for people with disabilities showed up and actually surrounded the building with their own wheelchairs. So they threw their wheelchairs onto the streets, onto the ground, in a circle, essentially forming a barricade around the building, so that the people who were trying to stop them had to physically climb over those wheelchairs in order to get into the building to participate in the hearings. And so they were creating the same conditions that they were facing themselves. They were creating that condition of inaccessibility for the folks who were trying to block their inaccessibility. And so it was such a powerful moment in that moment in San Francisco, but also in a number of similar protests across the country in the 70s and 80s. And it led to just a tremendous amount of attention to this issue of civil rights for people with disabilities, which was really critical for the Americans with Disabilities Act. So the Americans with Disabilities Act focuses on 4 major issues. They are employment, transportation, accommodation, and telecommunications. There was a precursor to the ADA called the Rehabilitation Act of 1973, so nearly 20 years earlier, But the Rehabilitation Act focused strictly on government agencies, and it restricted government agencies from discriminating against people with disabilities. And at that moment, in the concerns about that discrimination, it was especially focused on veterans and emphasizing the opportunity for veterans who may have received their disabilities while performing their service to their countries, to their country, to then not face subsequent discrimination after receiving those injuries and receiving those disabilities. So the Rehabilitation Act of 1973 introduced the idea of protective legislation for people with disabilities, but it didn't broaden it out beyond federal agencies. And so the Americans with Disabilities Act did that additional work. And it focused on these areas. So employment is really, first and foremost, it is about getting people into jobs, into the employment sector. And many of these people with disabilities are people who otherwise had been either institutionalized or taken care of by family members in family homes. So they were very much privatized. They were not operating in the public sector, either in employment or in terms of going out and participating in everyday public life, shopping, public parks, and so forth. And so these other areas helped with that by introducing non-discrimination policies in transportation, in accommodation, so hotels in particular, and in telecommunications, so making sure that people with disabilities had access not only to using telecommunication services like phones, but also having the services that they need to be able to consume television and other things that rely on telecommunications services. In the Americans with Disabilities Act, the following definition is used for disability, and I think what's critical is that it's not a list of conditions where one simply finds their condition and says, I'm listed here, therefore I have a disability. Instead, the term disability means, quote, with respect to an individual, a physical or mental impairment that substantially limits one or more of the major life activities of such individual, or a record of such an impairment, or being regarded as having such an impairment. So to break this down for a moment, notice that it says a physical or mental impairment. That idea of a mental impairment was relatively was seen as relatively problematic when it first came out. There was a strong understanding that physical conditions were agreed upon as being disabilities, but mental conditions, it was not so clear. So what kind of mental conditions would constitute a disability? That was something that ended up being debated upon quite a bit in Congress and the Senate leading up to the passage of the Americans with Disabilities Act. The idea of a record of such impairment implied that if you'd had a disability and then you had recovered from it in some kind of way, but you were remembered for that disability, that somebody could not discriminate against you for that. They couldn't say, well, I know you used to use a wheelchair, you used to have PTSD, and I don't trust you in my workplace, and therefore I'm going to fire you. So it protects not only an active and current disability, but also a historical disability. And then lastly, being regarded as having such an impairment. People make interpretations of each other all the time, and they might interpret a disability onto another individual and then act based on that interpretation in a discriminatory way. And so the ADA says, we're also going to stop that kind of discrimination. If you think someone has a disability, and in wrongly thinking so you discriminate against them, you have still committed a violation of this law. And so these are the major definitional statements about disability. And so it really goes down to this phrase: substantially limits one or more of the major life activities of such individual. And disability law, AD law, is primarily handled by courts, and so it's not as if every possible interpretation of that line is offered by Congress here. What is handled by the courts, by judges typically, is to say, what are the major life activities of this individual, and how are the life activities limited by a physical or mental impairment. And so there is a lot of subjectivity in that, but this is what we refer to as a social model of disability. Rather than listing a series of medical conditions and saying, if you have one of these conditions, then you have a disability, this is really about the relationship between the individual and the social world, the world in which they operate, which includes the working world, the family world, the community world, and so forth. If something about your body has a difficult interaction with something about your environment, then we describe that as a disability. And you could explain that by saying that the built environment wasn't built for your body, and therefore you are disabled by that built environment. And so to overcome for that failure of the built environment, we have this protective legislation. Now, when we think about disability case law, we get into the question of merit in terms of who's qualified to bring a case to the courts for consideration under the Americans with Disabilities Act. The ADA defines a qualified individual as follows, so I'm directly quoting here from the ADA. The term qualified individual with a disability means an individual with a disability who, with or without reasonable accommodation, can perform the essential functions of the employment position that such individual holds or desires. For the purposes of this title, consideration shall be given to the employer's judgment as to what functions of a job are essential, and if an employer has prepared a written description before advertising or interviewing applicants for the job, this description shall be considered evidence for the essential functions of the job. So qualified means qualified for the job, not is your disability a qualifying disability, which I'll get to on the next slide. It means, are you qualified for the job? Were you qualified based on the job description that was used when you applied for the job? Were you qualified for the job when you got the job? And if you are a qualified individual, then you qualify for the kinds of accommodations that the Americans with Disabilities Act guarantees you, the kinds of protections that the Americans with Disabilities Act guarantees you. So when it says qualified individual with a disability, it's just in that phrase, with the disabilities, referring back to that social model of a disability that was discussed on the previous slide. Another issue is the topic of qualifying conditions, which sounds similar to a qualified individual, but is somewhat different. It shifts the focus from the individual to the disability or to the medical condition. Qualifying condition is frequently and mistakenly confused for being an ADA issue when in fact it is not. There is a direct definition of a qualified individual in the Americans with Disabilities Act. There's no discussion of qualifying conditions. Qualifying conditions instead applies to Social Security and the Social Security Administration. If you look at the discussion of qualifying conditions in Social Security law and procedures, it does not include a list of specific conditions in the sense of specific disabilities. Instead, it applies a social model and focuses again on the ability to work. So a qualifying condition is considered a applicable condition based on its impact on your ability to work. So rather than, again, choosing from one or several lists of experiences of the body. It's about the relationship between the body and, in this specific case, work itself. So does it and how does it impact and impair your capacity to work and earn a living? So that is where the issue of qualifying conditions comes in, but it does not directly relate to the ADA. It comes in under this other umbrella of Social Security. So I want to turn to one example out of case law, and I call this Walmart versus Worker. In this particular case, I found a lot of descriptions about the case and its outcome, but the worker is not named. So this is not a case where it's Walmart v. Jane Doe or some other name. I simply find it as a case that is described as, particularly under a lot of description of epilepsy case law, as a settled case involving Walmart and an unnamed worker. So this was settled in May of 2018. Walmart announced a settlement with a optician who sued after being dismissed following having a seizure at home. It actually occurred back in 2015. She submitted paperwork from her neurologist documenting her condition and her need for an accommodation. Exactly 2 days later, her supervisor, the person to whom she'd submitted the paperwork, complained that she was a burden on the department, and she was suspended thereafter. So I want to take us through this case, looking at it from two different perspectives, including both Walmart's perspective and the worker's perspective. From Walmart's perspective, we could say, well, this is an optician. She has patients who are making appointments and counting on her to be ready and available when they come in to have those appointments. Her coworkers count on her to perform her job regularly without them having to step in and perform her functions on her behalf. Walmart employees have access to time off, including paid sick leave, and up to 16 weeks of paid maternity and parental leave. And so they have access to leave time that they can use when they are facing medical issues that could get in the way of coming to work. And so this really doesn't need to be treated as anything above and beyond that, unless she is going to be a burden, as her supervisor said, and ask for more beyond that. And her notification to her supervisor about her seizure, even though the seizure itself happened during her off time, the fact that she brought it to their attention seems to indicate that she's going to be asking for some undue burden, some greater service on their part to help her to achieve her duties on her job. From the worker's perspective, the worker was qualified to do her job and capable of doing it with reasonable accommodations. She'd been doing it for some time already. It doesn't actually indicate how long she'd been on the job, but we know she was not new to the position. Walmart is a large corporation with a large employee base, including within each region and in each store. Other employees were available to cover when needed. You could certainly take a look at any one given store and say, well, is there an extra optician for every hour of every day? Perhaps not, but Walmart does have typically have multiple stores in any given region. It wouldn't necessarily be a huge drive or huge difficulty for someone to drive a little bit longer distance on a given day to step in for this particular employee, given the high level of training needed to serve in this role. So there are ways to cover for this employee, and it might not be a drastic cost to the store to simply call in the optician who would have served a different day of the week and have them come in for a day to cover for this employee. Now, the actual legal outcomes are that Walmart settled for an undisclosed amount. The plaintiff's neurologist argued that she should have received an accommodation. Walmart had a fitness for duty doctor, that was the actual title, and that doctor actually argued that she should have received an accommodation. Walmart brought in an additional expert in the preparation for the trial, which never actually occurred, but Walmart's own expert argued that she should have received an accommodation. So Walmart had a lot of good reason to settle, and you can find a description of the outcome at the link that is posted on the page right here. Now, a few observations. The ADA is frequently equated with civil rights legislation. It's seen as something that brought the kind of civil rights that are available to racial minorities and to women, now being brought to people with disabilities. But many years later, that civil rights legislation is from the early 1960s. The Americans with Disabilities Act was passed in 1990. Notably, the Civil Rights Act of 1964 came out of the Judiciary Committee, and the ADA came out of the Labor Committee. So there's a strong focus in the ADA on restoring people to work rather than restoring justice. And that's a very important thematic difference that I would pay attention to in thinking about the Americans with Disabilities Act. And access to work is very important. I don't want to undermine that, but I do want to recognize that that's very different from the kind of focus on justice that we saw with the civil rights movement. The social model remains unknown or surprising to many, but it is more flexible and actionable than other models. So I find that when I explain the social model to a lot of folks, unless they happen to have been a disability studies minor when they were in undergrad or happen to take a disability studies class at some point, that it just isn't something that they've ever come across before. There's an assumption that a doctor tells you if you have a disability. And if you go and ask a doctor, they'll say, nope, it's not what we do. Doctors tell you if you have a condition and what your condition is. Whether or not that condition is a disability is a broader social determination in terms of the relationship between your condition and your social environment. And doctors don't have access to that social environment side of things to make those determinations. In the Walmart case, the ADA worked, and the court worked at enforcing the ADA to protect the workers' rights. So some action items in terms of the ADA. I think it's important that we promote better understanding of the Americans with Disabilities Act. In terms of stigma, we need to destigmatize disability, and we need to do so by avoiding the approach of subtracting conditions from the umbrella of disability while leaving behind the stigma. I'll often hear folks say, well, I have this condition, but it's not really a disability. My daughter has this condition, but it's not really a disability. My brother has Down syndrome, but I don't see that as a disability. There's an assumption that disability is a bad thing, and I'm going to rescue this person from that stigma by saying it's not a disability. A different way to approach that is more unifying of people with disabilities is to say disability can be a shared condition that should not be stigmatized, and to fight against that stigma altogether. I also believe that we need to promote the social model of disability more broadly so that there's a wider understanding of what that social model means, and we can do more to address the issues related to the built environment. That attempt to address the built environment was significantly advanced by the Americans with Disabilities Act, which did a lot to promote curb cuts for people using wheelchairs, and a number of other changes to the built environment across the past 3 decades. So we can certainly promote more understanding of that. And finally, I think we need to focus more on justice, and this gets at the fact that that the ADA came out of the Labor Committee and not out of the Judiciary Committee. We need to expand disability rights to focus on justice in all forms, and really get back to that sense that disability rights are about restorative justice for people with disabilities. Thank you very much.